We are live.
Okay. So, good afternoon to everyone. We are here to present a webinar with the theme of Sports Law and International Perspective. My name is Marcio Timóteo. I'm a lawyer at Legal Block, and I will be the moderator of this webinar. This afternoon, we will talk and listen about the global overview of sports in each country, which will have to be soon. Otherwise, it will take us all to a day, but I think a week maybe. Our first speaker will be Dr. Cenk Soyer, delegate in the Antalius Bar Association and lawyer at Soyer and Soyer. Avu Catholic Borosso, and we'll talk something like 12, 15 minutes. Please, Doctor.
Hello, dear all. First of all, I would like to thank for the Legal Block family because it's really good to be in here for talking with our audience and being with you. First of all, thank you for this good webinar. I hope it can be useful for our all audiences, and I think they can use it after the record. Okay, but first of all, I would like to introduce my city because it's important, and I think everyone can understand us very easily. I live in Antalya in Turkey, and Antalya is a very touristic place. But the another thing is very important for our webinar. Antalya is a capital of the winter football tourism because most of the teams comes to Antalya for the being in the transfer window and being a camp in here. So there is very live in the with the clubs, and then in the beginning I would like to tell all of the audience how you can be recurred with being a sports lawyer because it's really important. And I'm sure that too many students can listen us now. They listen us and they would like to know how to be a good sports law, the international requirements. So the first I have to express sport law is a multidisciplinary law. So yes, you have to be a good international law knowledge, and also the main principles of the punishment law is very important. You have to know this, and then also the main principles of the civil law. You have to know that very well because all of these laws mixes, and then the sports law occurred. And this one also we have to tell another things. The university level is very important in my view, and so you have to be a graduated in a good international law faculty, or maybe after the law faculty you can enter many different master program. And I attended many lecturer and also webinars, and in that experiences I saw that the important thing, the audience are more excited in your past and how you can be in here in the speech. So sometimes I use this method for easy understanding. I talked about my past, and the beginning is very important, my friends. In the beginning, what I did in the beginning, I would like to talk about my intern. In the intern time, I started in a sports law office in Turkey, and it is really important because in the beginning I learned too many things in there, and after that I decided to enter the sports law because I believe that sports law is a living style. If you prefer to be a sports lawyer, you have to manage your life with a sports law. It's really important. So then I started to work in a big, after the end of my intern period, I started to a very big Turkish sport law office as a lawyer, of course. And I took too many experiences on my pocket. It's really important because some of the most of the things in the sports law is very important that too many experiences you need in this industry. Then after many years have passed, and today we are coming here. The network is very important, our audiences, because first, for example, it's really I think good. I attended thinking football in the Porto, the end of the 2022, and there I met with the one of our attendants in here, and in this seminar, in this seminar, I met with her, and then now I'm in here. So network is very important in your job, and lots of the case we have many difference in the sports law country. Of course, you can't be in here all the time, so you have to you need a very large network for it, and you have to appoint one of your colleagues for this. So the network is very important. I'm sure that now the audience is very curious about how we get a very larger network, and it is, I think, quite simple nowadays, because the communication is very, nowadays is very large. So the social media is the, I think, right way. And LinkedIn, I think, is the best way of this, but also Instagram are also useful. So I think if you would like to be a sports lawyer, the network is very important, and you can improve your network with the social media. And also, as me, please don't throw out any seminar, the live seminar like in Porto. Okay, if you would like to be a sports lawyer, the very important thing is transfer period. This is our the busiest day, and we work too hard these days, of course. Let me explain what we do in transfer window. For example, I work with one of the Turkish Super League clubs, and every time our phone can be ringing. Because some of the colleagues, some of the players are South America, for example, and I live in Turkey. Of course, we have time differences between the two countries. So when the time is morning for the South of America, it means that you are at night. So you have to be awake all the time in the transfer period opens time. And also, of course, it is, we have to accept it. These days, everyone would like to agree with the transfer before coming together. So these periods are very exclusive times, and you have to be so patient. So another key is, if you would like to be a sports lawyer, you have to be patient. It's really important, my friends. And then I told time collapse, and also, of course, these jobs has many advantages about it, and some of the advantages is we travel a lot, of course, and it's really important, because if you have any travel accused, so this job is not for you, I think. But if you would like it, it's really good for you. So the travel is we travel a lot, and it is very good case of this. On the other hand, the communication skill is very important, because you have many colleagues and or clients, or the third party, other party. You can sit on the table, and on the table you have to negotiate all of the article of the contract. And of course, yes, you are a lawyer, but you can solve all of the things on the table, and a good communication is very important. You have to know the other party agriculture very well. It's really important because if you know the right culture for the speech, you can open easily all of the doors, and you can, I think, handle with the other party. It's really important things. And finally, I would like to examine that I have been in the sports law since 2008, so it means that nearly 15 years I'm in here, and I'm really interested in this area, so it is really important. If you would like to like a sport, of course, choose it. Otherwise, it is really boring, and it is really the strong, because you need a strong energy for this area. So this is the important part. Thank you very much. Now it's okay for my talking now.
Sorry,
Martin,
Mauricio, we
sorry,
can't hear.
you don't
Martin,
have
yeah.
sound.
Thank you, Dr. Cenk. Now it would be the turn of Dr. Renata Falcão, who I'm going to present as a specialist in civil, consumer and sports law and funding partner at Balbaki e Falcão Advogados. Sadly, Renata could not be present due to a contingency, but I believe that she will join us in a future webinar. So next we have Dr. Gavin Dingley, member of various sports panels, referee and mediator in the Qatar Sports Arbitration Foundation and lawyer at Five Paper. Dr. Gavin, please.
Thank you very much. So I'm a barrister at Five Paper in London. As you've heard already, I sit on various panels as an arbitrator in different sports, for example, boxing, hockey, canoeing, and athletics. I also am part of the International Volleyball Association Appeals Panel, which hears appeals from volleyball federations and players in respect of their status. I've been practicing as a barrister since 2015. So what I thought I'd do is give a sort of a brief background to sports law in the UK, and explain how things work here. And then, similar to my colleague, give you a bit of background as to how I managed to end up where I am, because I understand that students like to hear that to get ideas about how to do it themselves. So in terms of the structure of sports law in the UK, it's split up into domestic and international. So if we look at the domestic setting, there's a body called Sports Resolutions, which some of you might have seen. That is a body that contracts with many of the federations in the United Kingdom to deal with various sporting disputes. So when someone has an issue in relation to, for example, selection to go to the Olympic Games, they would initially challenge that decision, usually through arbitration at the domestic level, which usually involves a domestic arbitration at Sports Resolutions. Many of these decisions are not published because it's arbitration, unless the parties have obviously agreed that it can be published. So many of these decisions are not necessarily available to those who don't necessarily practice in the area, which does create its own degree of difficulty. In addition to that, we also have the UK Anti-Doping Authority, which regulates the anti-doping movement within the United Kingdom. They conduct all the testing, and they will also provide initial suspensions and sometimes prosecute the cases against athletes where they're found in breach of the anti-doping regulations. Many of those decisions are, of course, published, and those who are convicted or acquitted, there is, of course, a right of appeal onward to CAS, so the Court of Arbitration for Sport, from there. That's an automatic right. that an individual or federation has, as well as the UK anti-doping. So you'll see many of those decisions perhaps either at a high level or on the domestic level. Now, many of you may be interested perhaps in the Premier League, which has its own regulatory body, as well as the FA. Now, the FA, the Football Association, governs football generally throughout England, and that body would prosecute and regulate many of the footballers. So, for example, where you see breaches of disciplinary rules and so on, you will usually find that those cases are undertaken by the FA. Now, in respect of domestic transfers, so that's transfers between particular clubs in England and Wales, sorry, not England and Wales, England, there's a special regime called the Rule K, which is a set of arbitration proceedings which govern any disputes between any English clubs at any level. So that's the Premier League all the way down to the amateur level. Now, if a dispute occurs, that usually has to be undertaken under the Rule K procedure, and the FA would appoint an arbitrator, and that dispute is conducted in an arbitral setting. If there is, of course, a Rule K arbitration clause, which there usually is in most of these contracts. Where the agreement, for example, the sale of a player is international, so a Premier League club, for example, selling a player to the Bundesliga in Germany, you'll find that it's FIFA that regulates that contract. So any disputes that you have to go to FIFA rather than the Rule K procedure. So those are the different regimes. Of course, when there are disputes about selection and so on around the Olympic Games time, unless it occurs during the Olympic Games, in which case it would be heard by CAS, they are all dealt with at a domestic level in the first instance. So that's very important. Now, there are, of course, some sports that do not have arbitration clauses within their contracts, or indeed participation agreements. So, for example, the Lawn Tennis Association doesn't necessarily have one, which means that any disputes are dealt with at an internal level by the federation's own independent panel. So that usually is a group of people who are appointed by the federation, but they are independent of the federation to deal with the dispute. And they sit as either tribunal members or tribunal chairs to hear those disputes. And they decided at a domestic level internally. Now, there is an onward right of appeal to the High Court in those circumstances. And sometimes even there's an internal mechanism to appeal those decisions before one goes to the High Court to challenge it in the domestic courts. So that's how our system works. And in terms of how to become a sports lawyer, well, I think a sporting background is relevant, but not necessarily important. It does help. An interest in sport, I would say, is also not necessarily important. Being a good lawyer first is perhaps the most important skill that I would emphasize. So getting a good set of results from university and studying at the best institution that you can, and getting international experience would be the things that I would recommend that one does. An interest in sport comes secondary. Results are important, as are networking and expanding your network and meeting other people. Both those junior and senior to you is very important in terms of building your practice and meeting the right people. You should spend as much time as you can after you get a good set of results, meeting as many people as you can, because those are the people that will become your colleagues, your competition, and so on and so forth. And as my colleague identified earlier, it's very important that you know people in different jurisdictions, because there's no lawyer anywhere in the world that can handle everything. So the ability to network with others and refer work is very important, both in terms of creating relationships with other people and developing your practice internationally and your brand. That's very important. And I think in terms of globalization and how the world is changing, that's obviously very, very important, particularly if one wants to practice in sports law and get involved in different sports, because we are increasingly seeing players from different parts of the world playing in different leagues, which obviously requires specialist advice on different areas of law from different jurisdictions. The difference, perhaps, between Turkey and Portugal to England is that the systems are different. We have a system of common law, which means that proceedings are often adversarial with lots of advocacy and challenges to people's accounts. Whereas in civil law, so that's Portugal and Turkey, there's a set of rules that people subscribe to, and the arguments are premised upon a code. Ours is premised upon decisions from the court, so cases, and that is how we tend to manage our disputes. So thank you very much, and I'll pass on to the next person.
So thank you, Gavin. And now, at last but not least, Dr. Beatriz de Jesus Gonçalves. She's lawyer and partner at Legal Block and master in labor and business law with thesis in sports employment contracts. Please, Beatriz.
Good afternoon, everyone. Firstly, I would like to thank Gavin and Cenk for accepting our invite to be present. And also, I would like to thank Renata. She won't be able to be here today, but she will surely be present in future webinars organized by Legal Block. As Cenk said in the beginning, I met both Gavin and Cenk in the Thinking Football Summit in Porto last November. And I think that with both of you, I immediately thought about organizing this webinar, and I immediately talked to you about this idea. So my colleagues already talked a little bit about how it is to be a sports lawyer and the importance of having a good network and so on. So I will focus myself in specifics of the Portuguese regime that I think that it's important to understand when talking about sports law. So I'll choose two topics because otherwise I would be talking about this all afternoon or all week. I will talk a little bit about the differences between the labor law and sports labor law. And in the end, if I have a little bit of time, I would like to talk to you a little bit about the new sports company regime and the most recent alterations that the Portuguese government are wanting to do. So related to the first topic, I think that first and most important, the sports employment contract in Portugal is a term contract. So it means that it cannot have less than 1 year, except in some cases that explicitly are written in law, but it cannot have more than 5 years also. In case the athlete has less than 18 years, the contract cannot have more than 3 years. So in case the contract doesn't mention any term, we have to assume that it has the lowest possible term, that it's 1 year. Of course, that in opposition to what I just said, the regular regime, the contract must be an open-ended contract, except for the exceptions provided by law. The second most interesting difference that I would like to point is related to the trial period of the contract. So the sports employment contract, it has a trial period, but it depends in every case on the stipulation of the parties. So it cannot exceed 15 days in case the contract has less than 2 years, or 30 days in case it has more than 2 years. There's something interesting here, that the employer cannot summon up the trial period in three different cases. The first one is when the athlete participates for the first time in the competition, and that participation limits the participation at the service of another employer. The second case is when the athlete suffers an injury that will take longer to cure than the trial period. And the third and most interesting case, I think, and it's something that maybe we can discuss at the end of our webinar, is when the deadline for the registration with the respective sports federation ends. So it means that technically, if a club buys a player or an athlete at the 31 of August, for example, the law doesn't allow nor the player or the employer to have a trial period, which means that for all the purposes, the player is more protected, I think, than the employer. But it's very interesting to discuss this matter if you want in the end. Of course, that in opposition to what I've just said, in case the employment contract for the normal regime doesn't have any trial period, we consider that it was stipulated according to the labor code rules. The third specificity that I wanted to point is related to the possibility of the loan. Loan is not something that a normal worker can do. Okay, this possibility, contrary to what happens in the general regime, is seen as a normal and even as a way to enhancing the assets of the clubs. Since given the mobility that characterizes the employment relationship sport, it's intended to satisfy the interests of the three interested parties. So the club, the original club, the player, and the new club. In one hand, the worker may have the possibility of competing more and playing more, and the other hand, the original club is not doesn't have to have the asset that is not being used in his team. I would also like to point three matters there. I think that are very interesting in our regime. They are related to remuneration, disciplinary power, and breach of contract. I think these are the three most different points from the normal and general regime. And after, I would like also to hear Cenk and Gavin about how it is in maybe in England and Turkey. But in first place, sorry for the ambulances. In first place, and with regard to remuneration, it's important to emphasize that the clause in sports employment contract that makes a salary variation depend on a certain sporting result, such as a promotion or a relegation from division, it is valid. Okay, we can say that an athlete will earn more in the end of the month or in the end of the year if his club as a division promotion. Okay, it is valid. Still on the subject of remuneration, the sports employment contract regime assumes it does not support the principle of equal pay for equal work. It means that some things like the influence of a particular player or how he is perceived by the media, for example, can have an impact on how much this player will receive. So with regard to disciplinary power, it's important to understand that the party that causes the termination of the contract or that causes without just cause, for example, in the sports law regime, that party must indemnify the counterparty for the value of the remuneration that the athlete, in this case, would be due if the employment contract had ended in its initial term. It's, of course, a very different matter from the general regime. And I would lastly like to appoint that the sports employment contract in Portugal establishes the possibility of including a financial penalty in the employment contract in case of termination of the contract on the initiative of the employee. Okay, it was not like that some years ago, but the new law in 2017 introduced this new rule. But in my opinion, and sorry if I will be a little polemic here, the most interesting differences between the labor law and the sports employment contract and sports employment law is the provisions related to the restrictions on freedom of work. Okay, Of course, it was what I wrote in my master thesis, but I really think that it's very interesting to analyze how the Portuguese law perceives this matter. If I had time, I would talk a little bit about the Bosnian judgment and how it impacted not only the Portuguese law, but also the European law. But it's something that our viewers, if they want, can explore later, and we can talk a little bit about that further. Nevertheless, I would like to say some things that I think it might be interesting in this matter. First, the Portuguese sports legal system and contrary to what happens in the general regime, um, doesn't allow to have a non-competition clause. Okay, it specifically says in the law that it's not valid to have a non-competition clause in the contract, in the employment contract. Okay, but how can we change this? It's very important to understand. So, in the Portuguese sports legal system, the sports practitioner can only terminate his employment relationship by paying an indemnity set for the purpose, and provided that this possibility has been foreseen when signing the contract. This limitation can only be justified by the nature of sports contract and the order where each operates. However, the sports employment contract regime provides that any clauses limiting the freedom of work, as I've said before, that are included in the sports employment contract will be null and void. But what is interesting here is that the regime doesn't say anything about the transfer contract. So for those of you who are singers and are not familiar with the regime of the transfers, the transfer of a sports athlete normally comprises three separate contracts. The first one is the termination of the original employment contract. The second one is the signing of the transfer contract between the new club and the old one. And the third one is the signing of a new employment contract. As I've told you before, we already know that under the terms of law, non-competition clauses, Portuguese law, of course, non-competition clauses cannot be included in employment contract. But my question here, and I will answer and I will tell you my opinion, is not what the law says, because it's very discussed between authors and courts. Could these kind of clauses be included in the transfer contract or in the termination agreement of the original employment contract? I have to say that most of my colleagues in Portugal doesn't agree with me, but I will I will nevertheless tell you that I understand that in the light of Portuguese law, and since nothing is stated in the sports petitioner employment contract, the employer should be allowed to stipulate a non-competition clause in employment contract, not in employment contract, sorry, but in the revocation agreement. But it has to comply with the assumptions and with the things that the general law complies the general contract. So form, geographic limitations, and temporal limitations. So, for example, I really think that a clause like this cannot be longer than 2 years, for example, and cannot be for the whole world, but for example, another country, or I can give you an example, and maybe Gavin has a lot more to give me, I think. But it's very usual in Spain for new contracts signed by, for example, Real Madrid to have a clause saying that player that they are buying cannot be played with Barcelona for 2 years, for example. And I think that is something that, in the light of Portuguese law, it's valid, and I don't think any problem with that. Okay. With that being said, I don't know how much time I have, but I'm finishing. With that being said, I just summarized some of the, for me, most interesting things in Portuguese sports law regime. And I would like also to talk a little bit about the new regime of sports companies that the Portuguese government just approved. We are just waiting for the regime to be discussed to the final discussion. So it was approved by the government, and it reinforces the duties of suitability and transparency of these companies. Not only the companies, but also their investors and their directors. And it creates a specific regime of administrative offenses that was non-existent until now. For you to understand, around 20% of the sports companies in Portugal were on the way to extinction, insolvency, or dissolution in the last year. So, and the clubs that were with the sports company were being dragged down and were being finished by that. So, it became a priority to move forward and start adjusting the system and creating a new regime. And this regime is very interesting, not only because it allows the companies and the clubs with the companies to be more transparent and more sustainable, but also because it has a regime, as I was telling, of administrative offenses that, in my point of view, makes that the companies maybe think about acting a different way. So this revision was now approved, and I think that it's a new beginning for sports companies in Portugal, and we will be much more open to new investment after this new regime.
So many thanks, Beatriz Gonçalves, for your explanation. Now, given all these exciting developments from our speakers, I believe that it would be relevant and highly interesting discussing more a little bit about the new FIFA regulations, especially Dr. Gavin and Dr. Cenk. Please, we would look to listen what I have to say about this.
Gavin, you don't have sound.
Yeah.
If you don't mind, sorry, I said if you don't mind me jumping in first, I think the key things that I'm sure you'll all agree were first would be the licensing of agents, which is different. So anyone who sat the previous iteration of the exam, so that was back in 2008, and prior to that, they would be registered as an agent until the 1st of April 2015. So they're not required to take the new agents exam. It's only for those people who have been licensed effectively since. That would be the first thing that I picked up that's rather important. The next would be the eligibility requirements, which will no doubt affect many agents. So never being convicted of a criminal offence or involved in organised crime or something like that. Never being the subject of suspension or disqualification by a regulatory authority or sports governing body. Also, not to be an employee of FIFA, a confederation or member association, a league, a club, or a body that represents the interests of any clubs or leagues or organisation that is connected directly or indirectly with such organisations and entities, which makes the position of an agent now someone who has to be completely independent. And also they must not hold any interest in a club, academy or league. So many of the cases that I've done often have individuals who act as intermediaries or agents, which tend to have interests in academies, leagues, or other bodies. And they often use that as a way to get into the business in the first instance. So what you will now find is that football agents are going to have to be truly independent and represent their clients' interests, which I think is a positive step forward for agents internationally. I wonder what any of my colleagues have to say about that. Beatrice, Cenk?
Cenk.
Yeah. Okay. Now I'm listening. I think Gavin starts very well. First of all, we have to talk about this new regulation and the new things. And I think the criminal records is very important because in the beginning, I think this is very important things. And secondly, there is a new exam for the being a agency, but I think one of the important thing is clearing house. Because in the clearing house, it is a new payment system is coming with this, and it is really important in my view. Now, actually, we would like to be honest for all of the audience, and I would like to talk about the Turkish system a little one for the agency. Most of the contracts in Turkey, the agency fee is adding to players fee. So there is actually, in the meantime, there is no any agency fee, but of course the system has to block this because it's really important, and it is more, I think, good for the all party. So I think now FIFA would like to stipulate this new system for this because the control is very important, and also there is another main idea is 3%, you know, the limit for the agency, and it is really important. And one of the another case is the same agency do not make a process with the same date with clubs and the player. So it means that if there is a transfer in here and then the clubs has another agent, player has another agent, I think it is really important for this. So sorry, Mr. Marcio, if you would like to allow me, I would like to talk about the Turkish regime. Is that right? Or first of all, we have to close this topic for the agents topic, and then if you can give me a word, I would like to talk about something in the Turkish regime.
Yes, I think that we can.
I would just like to summarize what we just talked about the agents regime. It's curious that I think the both of you have just talked about the three main. I think the three main alterations of the regime, they are very important. One, the licensing, of course. Two, clearing house, as you have talked about. And three, and for me, it's the most important one. It's the regime for clearing the conflict of interests, as you were saying. In Portugal, it's very usual to parents being the agents of his sons, and after that, they also have the clubs. And it's very confusing. And with this new regime, it's much more clear. It's much more transparent. You can represent at the same time the buyer and the player, but you cannot represent at the same time the buyer and the seller. And I think it allows you to be much more transparent and to be much more compliant with the FIFA's regulations. And then you can proceed. Thank you.
Okay, so now Cenk, please.
Okay, now mute. Okay, in the Turkish regime is very similar, I think, with after Beatriz talking, I would like to express it because very, you know, the near time, I think 6 months ago, a new law can be occurred in Turkey, established, and it is exactly the same limitation in there. And also in Turkey, I think this is quite different from the, you know, the UK in my view, because in our board member actually has not a boss of the is not a main shareholders of the company. Actually, it is hearing strange, but because in Turkish legal system, yes, too many clubs is company now, and after the new regulation, new law, yes, it is being all of the professional clubs will be company at the end of this year. But this is really funny that no clubs, the board members and also the presidents are not the main shareholders. So it is another problems occurred. What is that? The board members has made too many transfers, and then they quit, and the debts are between the clubs and the fans, or maybe because the board members and also presidents quit for this. And the new regulation, the government tell that the clubs has a limit, the transfer limit, and this limit, below this limit, if the clubs can make a transfer, the board member and president has a personal responsibility for the steps. It's really important, because I think it is the same as in the UK and Portuguese. I'm not sure, but the companies has another the body, and companies' debts are just companies' debt. It is not occurred to personal, but in this new legislation in Turkey, it's really different, and now it is very now beginning. And also, according to this new law, it is quite different from the FIFA, that it is too much controlled on the club, and it is not quite good, because the government has too much control on the clubs, and it means that maybe the government can take a decision for the club. And also it's my opinion, and it is my alleged for this rejected for this new regulation, but I would like to examine that in the Turkish regime, that in Turkey take the most of the law from the European. So it means that also we regulated from the FIFA. It's also the very similar with the FIFA's rule in the Turkish Football Federation. So it means that not too many another things between the FIFA and the Turkish regime, but maybe I would like to tell, because all of the contracts, it is the same problem occurs in Turkey. Our expiry date of the contract is end of the May. In the Turkish Football Federation legislation is written there, 31st of the May, the contract expiry date. But some of the clubs, I know that some of the countries, so sorry, I know that end of the June of the the end of expiry date. So it is differences from the countries, I think. Also, of course, the Russia is very different league period. Also China, but these are different from the the European system. I think that's all for the Turkish regime, I would tell.
Okay. Okay, thank you. Now, Beatriz, do you have some more question or something else
Yes,
to introduce?
I just received a question in my phone. It's normally in our YouTube, but I will present to you the question that I just received for you both, Cenk and Gavin. Because I was talking about the non-competition clauses and how we have it in our regime, and these people wanted to know if, with your experience in the contract that you already seen in your careers, this is something that employees do in your regimes in UK and Turkey. It's something that is accepted. It is not how it works. Gavin, if you want to start.
Yes, so those types of clauses have real difficulty under English law, both from a competition standpoint and also are perhaps perceived as being overly restrictive. So they tend not to be present in any of the contracts that I've seen. And indeed, I would have thought that if you did have a clause of that kind, that it wouldn't be deemed as valid by an arbitral tribunal on the basis of unlawfulness. So yeah, it's very different to perhaps the regime in Portugal.
The non-competition means this topic in Turkey, I think it's void, because the same times sometimes we can demand from the other party, other country, can the same articles for this, for the non-competition things, but it is not forced in Turkey. So I think my answer is very nearly is the given.
Okay. So I don't know if you know the player João Mário. He played for Sporting in Portugal, and then now he's playing in Benfica in Portugal. But he originally went from Sporting to Italy, and when he transferred to Italy, it had a clause saying that he cannot play for Benfica in the next 2 years. So he waited 2 years or 3, I don't remember, and then he returned to Sporting, and then he played to Benfica. So it's something that it's very normal to be done in Portugal. I know that in Spain is also very normal to do so, but I wanted also to know how it works in UK, obviously, and Turkey.
May I be first? Yeah. I think, most of the FIFA decision in the DRC, there is a written there. You have to give a player to, the play football. It is the club's first obligation. And so, in my view, I think this article is void. I think if I don't remember any case for this CAS or the DRC, because actually we didn't I didn't talk about it, but dear audiences, if you would like to be a sports lawyer, you have to analyze lots of the CAS decision and also FIFA DRC decision. It's really important for our job. And I don't remember anyone, but in my view, I think this article cannot be used. I know it is another article but for example, I would like to give an example for this. For example, in one of my contracts, it is written there, the clubs has decided that the player can train alone or another team, and also the clubs measured that article to player, and player went to filed against to in FIFA and also then CAS, and player won the case. I know that case. I've written it. I wrote it. I read this. So it is really important that the club's first obligation is playing football to give a football to player. So I think it's a void, but I'm not sure. We have to look for in the decision of the CAS and the FIFA. Thank you.
Okay, thank you, Cenk. Now, we have a question by Dr. João Correia, who is a lawyer. And the question is, do you think it's a valid clause, the sale option clause in the end of the season, just to dribble the FIFA financial fair play? I think, I don't know who is the question, but I think it will be fine if the three talk about this question. Gavin, please.
I'm not sure what he means by dribble. To get round, is that what he means?
Yes.
Yeah. Okay. I think that might. Well, a sale clause at the end of the season. Well, it depends on the. I think just looking at that question in isolation is difficult, because one would have to see what the entire contract says rather than just looking at an isolated part of it. The mere fact that the contract is valid for 1 year with would indicate that the player can be sold. Indeed, if it's a contract for 2 years with an option to sell, I can't see how that's a problem. But as I said, without seeing the entirety of the contract, it would be difficult to assess whether that clause in itself is unlawful or not, because each contractual term has to be viewed into the context of the contract holistically, rather than just looking at an isolated term. And in fact, that's how most of these contracts are looked at, rather than in isolation. I can't see any problems with that personally.
Okay, Cenk.
Now I think the audience examined that the end of the what I understand there is a sale option of the contract listed in this, and for this you can get through this FIFA financial fair play. Is that right? So you can
Yes.
know this. Okay, I see. I think some of the times we use it, and no one can block about this contract for the FIFA financial fair play, because why? It's really that the player demands and the club's demands about it. Sometimes it's really important that. So I think every time do not think about that it is for the FIFA financial fair play. We can do or write down for this. Every contract has another story, and in this story sometimes clients demand this, and we can use. I think no, I don't think so. It is a triple for the the FIFA financial fair play in this article.
Okay, thank you, Beatriz.
Yeah, I think that in general, of course, the sale option clause is valid. It's but as Gavin was saying, how can we, without seeing the contract, and how can we, without knowing what was behind the contract, know if they intended to go around the FIFA transparency? It's very difficult. Just the clause, it's valid, it's not void, but we cannot ever know if it's an escape or something like that. So it's very difficult to answer this question properly, because as Gavin was saying, of course, we don't have access to the contract. We don't know how and when it was signed. So it's very difficult to answer and to have a secure answer.
Okay, thank you. Now, if I have a question for three. If not a deal in the other season, but if in this season the club do not can't buy, but if they make a loan with a huge payment in the next season by a hypothetical clause, and the three understood my question.
You mean that is it against to FIFA financial fair play? Is that
Yes.
right? Yes. Okay, I see.
I pay the loan, but pay just in the end to dribble, as John says, the financial fair play with a huge payment. This makes the difference.
Yes, okay. May I be first?
Yes, please.
Okay. No, I don't think so. You can use this way easily, and it is really the common things. We use it every time. If the clubs has a problem with a financial fair play, so of course we can write down this year is a a minimum amount, and the second year is a huge amount, and so we can use it, and I don't think so it is against the FIFA fair play, financial fair play. Thank you.
Okay, thanks, Gavin.
Yeah, the same answer. The only thing that I would say is that sometimes to legitimize something like that, one could also put in dependent clauses. So if the player had scored 5 goals in a season or made 30 appearances or something like that, then additional payments would be due. The only problem that you come with inserting those additional caveats to the contract is similar to what you saw in Spain at Atletico Madrid, where a player is not being played because if he gets played or comes past a certain number of minutes, the club then has to pay more money. So these clauses need to be thought very, very thought out very carefully if they include contingency aspects. So, for example, number of minutes, number of appearances, and so on. So that's always a huge risk if you include that in a loan agreement, for example, which is very common. But there's nothing to stop you structuring the payments over a longer period of time to be greater in 1 year than another. But often you'd need to have some sort of justification for that. In general, you don't have to have one, but one would expect that.
Okay, thank you. Beatriz.
Yeah, I was thinking on the same answer that Gavin just gave. So I don't see any problem on doing that. But normally, of course, clubs and athletes use that that kind of specifications, like how many games you have, how many goals you have, to round this kind of problem. But yeah, I don't see a problem on doing that, and I don't think that paying more at the end of the loan or something can be used as a problem.
Okay.
We have a question.
Okay, now we have a question by Catarina Carvalho. The question is, I would like to know what's your take on the legality of termination clauses. So now I will change the order. Beatriz.
Yeah, that's, I don't know how it is in Turkey and UK, but I know that's something very discussed in Portugal, not only for the legality, but also because of the amounts that now are being practiced, as you know, better than me. In Portugal, normally people say that, of course, it's normal to do so in every contract and in every sports contract, but it can be seen, it can be foreseen as a limitation for the player and for the worker of its freedom. And of course, if we are being legal, as said, if it's a limitation of the freedom of the worker, it has to be void. But of course, it is not. We do often these kind of clauses, but the problem right now, in my point of view, is the amount that we are using in this kind of clauses. The amounts that we are using in this kind of clauses, they are absolutely huge, and I think that sooner than later, the clubs will have much trouble to compete with each other due to this kind of termination clauses, and it will create an even bigger difference between the bigger clubs and the lower division clubs. But it's legal, of course.
Okay, thanks. Now, Cenk.
Yes, in the termination clauses, we can actually write down many things for the doping agents, doping clause, and the media clause. Sometimes the any disciplinary measures for the players, and also the players has a huge the right is if the clubs in the first obligation of the paying the clubs is non-paying that, yes, the players can also terminate the clauses. What my experience is, of course, I have seen too many contracts, the loss of the world, and I see that I think the main ideas are all the same. And if there is a doping, if there is a the measures, discipline measures there, yes, the clubs has a right to terminate the contract. And secondly, if the clubs has not a payment debt, the FIFA, in the FIFA regulation, according to FIFA regulation, there is written there, they can write down the termination of the clauses there. So of course it is a legality, but of course we cannot meet any article of the contract what the stipulated in the regulation. So if something write down in the FIFA regulation, we cannot put it on the contract indeed. But if there is a the gap
in this contract, yeah, in the regulation, we can write down this. It's my answer for this.
Okay, thank you, Cenk. Now, Gavin.
Yeah, I think again it depends on the context of what we're talking about here, about what's happened and why the termination clause has been triggered. So that really, again, is context dependent. There are a variety of different reasons why there are termination clauses in contracts. Often they're to do with anti-doping or disciplinary measures, for example. But as you saw in the case of Ronaldo, it could simply be speaking out, which may be a breach of the club's policy and conditions within the contract. Often what happens is if that there is a breach, then the club is justification for termination. Where there isn't justification for termination, obviously there tends to be litigation. So in the context of a English club dispute, that would probably go to Rule K arbitration, where the legality of the termination of the player would be discussed. But if there's any breach of the disciplinary regulations or anti-doping policy, termination isn't entirely justified, often without compensation.
Yeah, let me just add something. I saw this question on the light of the termination clauses in case one club wants to buy an athlete without having just cause to terminate the contract. I answered with that light. Okay, it's just not having just cause, not having any problem. Just one club wants to buy an athlete, and the original club doesn't want to let them go, and the new club has to pay the termination amount. And that was my answer was on that light, because obviously the termination clauses have a huge amount of things that can be inside, as you were discussing. But what bothers me and what my main bothering is with the amount that these kind of termination clauses represent, and the differences between big clubs and small clubs that these can represent.
Okay. Yeah, I've done a number of cases at CAS actually that involve this principle of termination of the contract solely to avoid paying sell-on clauses in contracts. So, and the position of CAS is if it's done in this way, then obviously it's not valid unless there's a justified reason for the player being terminated. But if it's solely to avoid paying a transfer fee or indeed a sell-on fee, then obviously that's not justified. That's the general position of CAS.
Yeah.
Okay, so more any opinions about this team?
No.
No. Okay. Beatrice, do you have the information of more anyone question? I don't have.
No, we don't have more questions for now. If we do, I will send them to Cenk and Gavin, and if they are willing, they can answer later. I just want to thank you once again for being here and for accepting our invitation. And soon we will meet again, I'm sure.
Yes.
Right. Thank you. Yes, please, Cenk.
Thank you very much for this webinar, and it's really quite good for being with you guys. And I hope for the audiences, I think it can be useful for everyone, because it is not quite easy for being a sports lawyer. But when just in the first contract, it is really difficult. But after that, everything is the same, and every job has another story, and it is good, I think. And also, there's a network needs. There is, too many, the travel, and most of the time we are writing down on the mail, and I think it's good. I hope lots of the audience can prefer being a sports lawyer, and I hope it's useful. Thank you very much again, Gavin, Beatriz, and Marcio, and the Legal Block family.
Thank you, Cenk.
Thank you very much for having me and for arranging Legal Block. So thank you very much.
Okay, thank you of the three. I think there are a grateful time, and I think that we are grateful for their willingness to teach us more about this aspect of sports law and we are very grateful to these 3 amazing speakers. And I think that's all.
Thank you.